This is the Parliament Channel and Parliament Radio 105.5 FM.
Howard Chin-Lee served as a temporary opposition senator during the 6th Republican Parliament in 2001. During the 7th and 8th Republican Parliaments, Mr. Chin-Lee would serve as a senator and Minister of Government, first as Minister of National Security and later as Minister of Tourism and Minister in the Ministry of Public Administration and Information. Mr. Chin-Lee is currently the Managing Director of Synergy TV. Clyde Adams served as a temporary opposition senator on one occasion during the 8th Republican Parliament. He made his maiden contribution during debate on the Tobago House of Assembly Amendment Bill 2006, an act to amend the Tobago House of Assembly Act 1996. Mr. Adams currently resides in Tobago and is heavily involved in cultural productions.
This is the Parliament Channel and Parliament Radio 105.5 FM.
Razia Ahmed first served as a government senator during the 6th Republican Parliament in 2001 and as an opposition senator during the 8th Republican Parliament in the years 2002 to 2007. She would again be appointed a senator in 2013, this time as a Minister of Government in the People's Partnership. Mrs. Ahmed was then appointed President of the Senate on February 3, 2015. She is currently an agency manager at a prominent insurance company and advocates social justice.
This is the Parliament Channel and Parliament Radio 105.5 FM.
Hazel Manning first entered Parliament as a government senator in 2002. She has served as Minister of Education between 2002 and 2007 and was appointed Minister of Local Government in November 2007. Her career has included working in various agencies, including the Town and Country Planning Division of the Ministry of Planning and Development, where she was head of its research unit. She also worked for several years as a social impact assessment consultant. Mrs. Manning is currently retired from politics and leads a private life.
Follow the Parliament of Trinidad and Tobago on Twitter. Our call sign is @TTParliament.
Deputy Speaker.
We now return to our coverage of the 13th sitting of the House in the second session of the 11th Parliament on Monday, December 12, 2016.
Honourable members, the House will now go into the Committee of the Whole. Honourable members, each member should have a list of amendments before them, and we will proceed to go through each clause by clause.
Clause 1.
Shall we do the title first or last?
Last.
Title.
The question is that clause 1 now stand part of the bill.
Yes. Yes.
Okay, Mr. Deputy Speaker, we have an amendment to clause 1. The purpose of the amendment to clause 1 is to make it crystal clear that this legislation is confined only to tax information exchange, a tax information exchange agreement with the United States of America and no other country. I will ask the AG now to elucidate.
Thank you. Thank you, Mr. Chairman. For the benefit of the House, Mr. Deputy Speaker, the original architecture of this bill proposed that the Tax Information Exchange Act allow for every tax information agreement that came forward to be incorporated by way of an order. It meant that this act, before it was amended, could have been used not only for the United States of America, but every other country. As a result of some of the observations presented by a number of contributors, Banking Association, Central Bank, Board of Inland Revenue, and the opposition in their statement of Friday, 23rd September 2016, we had to reorganize the structure of the bill so that each bill that concerned tax information exchanges would stand as a separate bill of Parliament. For that reason, the amendment to the long title, which will find itself in all of the clauses proposed for amendment this afternoon, specifically requires that we only use this particular piece of legislation for the two United States of America agreements.
The short title.
The short title.
Short title.
The first one would be for the 1989 IGA, which was under the Tax Information Exchange 1989 legislation, and the second one specifically for the 2016 IGA. Any other tax information exchange agreement, be it with the Global Forum or any other country, would have to come by an individual piece of law, each one standing on its own, and that's the rationale for this particular short title amendment.
Honorable members, the question is that clause number 1 now stand part of the bill as amended. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 1 now stands part of the bill
As amended.
as amended. There is a proposed new clause 2. This new clause will be taken at the end. However, I will allow an explanation.
Certainly.
Proceed, Minister of Finance.
This clause provides for the Act to come into operation at a date fixed by proclamation. Reason being that there's a lot of preparatory work necessary after the Act is passed. After the bill is passed, the central bank will have to prepare the guidelines in consultation with various institutions, and the Board of Inland Revenue will have to put its house in order to allow the automatic exchange of information with U.S. Treasury. And therefore, after the bill is passed, we've put this new clause in to allow a proclamation date, which will be at some point in time after the passage of the bill, but well before the 30th of September 2017, which is the deadline. I don't know if the AG wants to add.
Member.
Yes, please, Mr. Chairman. Thank you. Mr. Chairman, just to remind that the observations of the United States of America set down 2 milestones, as the Minister of Finance has clarified for us today or repeated. The first one was in the month of February 2017, and the second one in the month of September 2017. This law requires a 2-stage process. One is for the technical compliance, meaning that you actually have a law to do the tax exchange of information, exchange of tax information on foreign accounts. And the second side of it is that you physically engage in operationalizing that law. For that purpose, therefore, the proclamation clause is explicit in its design to allow for the separation of the 2 functions, the compliance of the law, which must be done before February, and the operationalization of the law to be effective before September.
Okay, members. Question is that clauses 2 and 3 be renumbered as clauses 3 and 4. All in favor, say aye. Aye. Any against? The ayes have it.
Clause 3 as renumbered.
The question is that clause 3 now
We have an amendment
for clause 3
as renumbered.
as renumbered.
And this is just a simple stylistic, linguistic correction to make it clear that the Act has effect even though it is inconsistent with sections 4 and 5 of the Constitution. Okay? I don't think that needs any further. It's just an English correction.
Honorable members.
But I want to stress that that is a very important point, that this Act will require a special majority.
The question is that clause 3 as renumbered now stands part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 as renumbered now stands part of the bill as amended.
Clause 4 as renumbered.
Questioning,
Amendment.
members? Proceed.
Now, this is a very important amendment, and this goes to the core of many of the objections of the absent opposition. This deletes the minister as the competent authority with respect to a tax information exchange agreement, and also deletes the concept of multiple states from the agreement. So The effect of this amendment will be, to repeat, to delete the minister as the competent authority, and also to delete the concept of contracting states, and to make some other changes to make it clear that the only declared agreements that we will be dealing with respect to this legislation are the original 1989 tax information sharing agreement and the new 2016 intergovernmental agreement signed between the United States of America and the Republic of Trinidad and Tobago. And it goes on to delete any reference whatsoever to other agreements and the concept of multiple agreements and so on, which is something that the other side had complained about bitterly. We've taken that all out, so the minister is no longer the competent authority. We've also removed the power of the minister to authorize persons to act as the competent authority, because we are designating the Board of Inland Revenue as the competent authority through this legislation. So that, as I said, goes to the core of many of the objections of the absent opposition. I will ask the AG to elaborate.
Mr. Chairman, I adopt everything that the Minister of Finance has said and wish to just elaborate as follows. In the present architecture, because we are now confining this bill solely to the United States of America, that is the 1989 law and the 2016 intergovernmental agreement, we have removed the definitions appearing in old Clause 3, and they now find themselves in the body of Clauses 5 and Clauses 9. Clause 5 appears in Part 2 of the bill and deals specifically with the 1989 agreement. That is the 1989 TIA under Part 2. And Clause 9 deals specifically with the 2016 intergovernmental agreement. Now, Mr. Chairman, it's important to put on the record that the language originally proposed in this bill, which stated that the competent authority was the Board of Inland Revenue or such entity appointed by the Minister of Finance, was the exact language of the IGA, both in 1989 and in 2016. Notwithstanding the fact that that was signed as an obligation by Minister Hawaii under the UNC government, and that this Minister of Finance was bound by law to treat with it as he met it, because a state can't reverse its position once a treaty has been signed. Notwithstanding the fact that the last government bound this Minister of Finance to do that, in view of their insistence that we should reverse the position, we have found the easiest way to do it in law, and that is to refer back to the original definitions in the 1989 and the 2016 IGA and Tax Information Agreement, and therefore to remove, out of an abundance of caution, the references to minister. It is an inconsistent position for the absent opposition. I want to remind that in their publication of Friday, 23rd September 2016, which is the only contribution we have had from them on specific observations on this bill, the exchanges in relation to Clause 5, Clause 6, Clause 7, Clause 8, had specifically to do with the referencing to the word minister in an attempt to meet those concerns expressed by them, and on none of the occasions any concerns expressed in the 5 times we've debated this bill, we made these amendments.
Honorable members, the question is that Clause 4, as renumbered, be amended and amended as circulated, will now stand part of the bill. Those in favor, say aye. Aye. Those against, say no. I think the ayes have it. The question is that Clause 4, as renumbered and as amended, now stands part of the bill. The question is,
Original 4.
the question is that the original 4 be deleted as circulated.
And that's an amendment that we are proposing, Mr. Deputy Speaker, and that again is to remove references to multiple agreements, making it again crystal clear that the only agreements we're dealing with are the 1989 and the 2016 foreign tax account agreements with the United States of America.
Mr. Chairman, insofar as the original 4 specifically said, the minister may authorize any person to act as competent authority for Trinidad and Tobago and for the purpose of any tax information exchange agreement, I just wish to add, again, it's the absent opposition's insistence that the minister's reference be removed, and that has been achieved. This has been signaled now 3 occasions prior to this that these amendments would have been put forward. Again, we regret that the opposition is not here, even though we have said this on the Parliament floor. It's now pellucidly clear these amendments, this amendment to this particular strikeout to clause 4, was circulated to the opposition in hand since the 23rd of September 2016, Mr. Deputy Chair, Mr. Deputy Speaker, Mr. Chair, and in those circumstances, it's now proposed to deal with it that way.
Let me come back again, Mr. Deputy Speaker, Mr. Chairman. The original clause 4 read as follows. The minister may authorize any person to act as the competent authority for Trinidad and Tobago for the purpose of any tax information exchange agreement. And the opposition objected violently to that, and we have deleted that clause. So the minister can no longer authorize any person to act as the competent authority. And we are authorizing at one of the concerns they raised, we are going to authorize the Board of Inland Revenue and no one else to be the competent authority. So that's the effect of this amendment.
Sure.
Take out the minister's power to do that.
Honorable members, the question is that the original clause 4 be deleted. All in favor, say aye. Aye. Any against? I think the ayes have it. The question is, the original 4 is deleted. Members, part 2.
Yes, I think I kind of jumped the gun. In speaking earlier, we are deleting the heading so that it takes away the concept of multiple agreements and makes it clear we're just dealing with agreements with the United States of America. Okay? Yes, all of part 2 is being deleted. And if I can go into clauses 5, 6, 7, and 8, which is all of part 2, I'm going to go through this slowly. The original 5 gave the president, which in this case would have been the cabinet, the government, the power by order to declare a tax information exchange agreement to be a declared agreement for the purposes of this act. Again, this was a concern raised by those opposite and other commentators that the cabinet should not have the power to declare agreements that it entered into with other countries, declared agreements without coming to Parliament. So we've taken that out. 6, the minister or any person authorized by him that shall ensure that effect is given to every declared agreement. And that's 6.1 and 6.2, where the minister authorizes any person under subsection 1, he may give general directions to such person as to the performance of his functions under this act, and such person shall comply with any directions given. Again, that was abhorrent to members opposite. The very idea that a minister could ensure that a declared agreement is given effect, and that a minister could authorize persons and give them general directions with respect to giving effect to an agreement. So we've taken that out. So the minister no longer has the power to authorize persons and give general directions. With respect to 7 read as follows. The minister or person authorized by him has, for the purpose of giving effect to a declared agreement, all the powers that he would have if he were acting generally for the purpose of, or for any particular purpose specified in any act that confers powers on the person. And then it went on to say at subclause 2, any power under subsection 1 is exercisable notwithstanding that the circumstances, if any, necessary under that act for the exercise of the power may not have arisen, and subject to subsection 1, the provisions of that act shall apply to and in relation to the exercise of that power for the purpose of giving effect to a declared agreement as if the power was exercised for the purpose of that act. Again, this was abhorrent to the members opposite, that the minister would have the power to act specifically and generally and exercise powers with respect to giving effect to a tax foreign account agreement. So we've deleted the minister's powers with respect to that, and everything will now reside in the Board of Inland Revenue. And 8, the final clause in Part 2, which is now deleted in toto. In 8, it says, yes, 8 is coming out of here and going into another section, and 8 dealt with the Income Tax Act, the Data Protection Act, and so on. And since we're taking out Part 2, and this is important, we are putting it back elsewhere. AG?
Thank you, Chairman. Mr. Chairman, I want to refer again, because there's no opposition present, to the publication of Friday, 23rd September 2016. The opposition specifically indicated objection to Clause 5, Clause 6, Clause 7 of the bill before us. These clauses, Clauses 5, 6, and 7, are being entirely deleted from this bill. We said this to the opposition on the floor of the Parliament 3 occasions ago when we stood. We are now on the 5th occasion. This has been communicated in the public domain as well. I think it important because they're not here to put it on the record. These amendments were also circulated to the opposition as well. I remind that this particular statement by the Leader of the Opposition, 23rd September, had only 6 clauses, 5, 6, 7. 3 of them have come straight off the table. Mr. Chairman, I wish to put further that the removal of these particular clauses, as is now proposed by amendments, are managed because the position of putting the order in is no longer going to be a problem for future bills, future other agreements, because they will each one on its own. The 1989 provision allowed you to have declarations of this type. You could have come forward. You could have brought in other agreements. We have now said we will take it the long and very difficult route, and we will instead do each and every tax exchange information request by separate legislation. The country had an alternative, which has stood in the law since 1989. Member for Caroni Central was a part of the government that passed that law then. The opposition as last government presided over this existing law for 5 years and had nothing to say about it. Notwithstanding that fact, this is a special majority bill. We have taken these clauses entirely out, and Clause 8 itself, which is now going to come back as a new Clause 12, has been amended so that we can take into inclusion more than just Sections 6, 41, 42, and 46 of the Data Protection Act. Instead, Mr. Chair, we now have the opportunity to include Sections 6, 30, 31, 38, 40, 41, 46, and 69 of the Data Protection Act. And this allows us, therefore, to do a further and better cross-check. Thank you, Mr. Chairman.
Honourable members, the question is that clauses 5, 6, 7, and 8 be deleted. All in favour, say aye. Aye. Any against? The ayes have it. Clauses 5, 6, 7, and 8 are deleted. Honourable members, clauses 9 to 11 are, as a consequence, renumbered as clauses 5 to 11. 5 to 7, my apologies.
Part 3.
Part 3, delete the heading title, Part 3, Roman numerals, and replace with the following new title head, Part 2, Roman numerals.
Clause 5 is renumbered.
The question is...
We have an amendment.
Hold on 1 second, member.
Yeah, sure.
The question is, Clause 5, as renumbered, now stand part of the bill?
Yes, we have an amendment, a very important amendment. because, again, this goes to the core of the objections from the opposition, where they saw the minister as some sinister entity doing all kinds of strange things. So in order to avoid that argument and that old talk, if I could use that language, we are now making it crystal clear that the competent authority who will be sharing foreign account information with the United States Treasury will be the Board of Inland Revenue, which in itself is bound by privacy considerations. And we are also deleting the definition of national. The original definition was national means any individual possessing the nationality in Trinidad and Tobago, or any legal person, partnership, or of association deriving its status as such from the laws in force in Trinidad and Tobago. And I will hand this over to the Attorney General.
Thank you, Mr. Chairman. Mr. Chairman, specifically, the opposition did not object to Clause 9, even though there was the reference to Minister. But the Minister of Finance, in being crystal clear to take on board their objection, even though they didn't specifically raise Clause 9, has deleted the definition, proposes the deletion of the definition of the words including as authorized representative of the minister. It is incumbent, however, to remind that this definition of competent authority is the very definition in the 1989 law that has stood on the books of Trinidad and Tobago until today's date. Secondly, it is the same definition contained in the Intergovernmental Agreement and the 1989 positions. However, in a move to have consistency, we have sought and we now propose to delete the references to the words minister. Mr. Chairman, the deletion of the concept of national was to take account of the fact that this definition exists in the IGA itself, and in those circumstances, we propose not to include it in this bill.
Honourable members, the question is that Clause 5, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question now is that Clause 5, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 5, as renumbered and as amended, now stand part of the bill.
Clause 6, as renumbered.
Any amendments? No amendments. The question is that Clause 6, as renumbered, now stand part of the bill. Those in favour, say aye. Aye. Those against, say no. I think the ayes have it. Clause 6 now stands part of the bill.
Clause 7, as renumbered.
The question is that Clause 7, as renumbered, stand part of the bill.
We have an
Honourable
amendment.
member.
Yes, as circulated. It's correcting some of the language. We are identifying the person. We're identifying the person in the persona of the Secretary to the Treasury to make it specific as to who is the entity on the other side, well, who's the person on the other side, the responsible person to receive information. We are changing it from the Treasury Department, which is a kind of nebulous thing, to the Secretary of the Treasury, who is a named individual. There's also consequential or typographical change to the first section, where we change 10 to 6 because of changes we made before. On the other side, in the next part of the clause, we're amending subsection, well, 3 would be, again, bringing in the person of the Secretary to the Treasury, and subsection 5, we're deleting that and replacing it. Subsection 5 read as follows. Where a request is made for information under this section, the board shall provide the information in the same form and manner as it would have required it to have been provided had the request been made with respect of taxes under the laws of Trinidad and Tobago. Well, that really didn't deal with the issue. So, because we're providing information to the United States. So we're changing this to make it more relevant to the following. Where a request is made for information under this section, the board shall provide the information in the same form and manner as the Secretary to the Treasury would have required the information to be provided. We're trying to cut out some bureaucracy there. And then, very importantly, in subsection 7, subclause 7, further subclause B, so that's subclause 7B, we are now making it crystal clear that the Board of Inland Revenue, who now is the competent authority, is not required to supply information to the U.S. Treasury that is not obtainable under the laws of Trinidad and Tobago. So the Board of Inland Revenue is not getting any additional powers to go and seek out secret information that persons may have somewhere. What this now makes very clear is that only the information that the Board of Inland Revenue can obtain in the normal process under the existing laws of Trinidad and Tobago is what will be transmitted to the U.S. Treasury as and when required. Attorney General?
Just two additions. Firstly, in respect of the subclause 5, it really is to make sure that it is clearer that the information must be that of the type requested by the Secretary of the Treasury, as opposed to the reference to the word "it" contained previously, so it makes it clearer for application. And very importantly, in subclause 7B, it is to remove the words "or in the normal course of the administration of Trinidad and Tobago," such that we limit, therefore, the specific power of the Board of Inland Revenue to supply only information which it could by law supply. The removal of the words "or in the normal course of the administration of Trinidad and Tobago" could have invited for an expansion of disclosure, and we wished to circumscribe that disclosure. I should add, Mr. Chairman, that the observation contained in the statement by the opposition leader Friday, 23rd September 2016, simply confined itself to the minister's exercise of power, and it did not go to the circumscription of the extent of information which the Board of Inland Revenue itself could have. So we have reached beyond their observations and tightened the law, notwithstanding the fact that they have not made that observation. We have taken the opportunity to tighten it ourselves. Thank you, Mr. Chairman.
Honourable members, the question is that clause 7, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question now is that clause 7, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 7, as renumbered and as amended, now stand part of the bill. Honourable members, there is a proposal for a new clause 8. This new clause will be taken at the end. However, I will allow an explanation at this time. Member?
Thank you, Mr. Deputy Speaker, Mr. Chairman. The 1989 Tax Information Exchange Agreement, which has been in effect now for 27 years, is to be preserved so that the 2016 Intergovernmental Agreement does not supersede the 1989 Tax Information Exchange Agreement. It simply enhances it and includes new provisions that have come up in the last 27 years. So that we want to make it clear that certain laws that would have been passed between 1989 and 2016 would not affect the operation of the original 1989 Tax Information Exchange Agreement. So that is why we have the words "nothing" in Section 4 of the Income Tax Act, Sections 630, 31, 38, 40, 41, 46, and 69 of the Data Protection Act, or any other law, prevents the disclosure of information where that disclosure is in accordance with the 1989 Tax Information Agreement. It goes on to add an offense that where information has been obtained or received under this act or declared agreement, a person who uses or discloses the information other than for the purpose, again going to the core of the objections of members opposite, a person who uses or discloses the information other than for the purposes for which it was obtained or received commits an offense and is liable on summary conviction to a fine of $30,000 and to imprisonment for 2 years. So that addresses the issue raised by the opposition that the information that is going to be obtained could be misused and abused for other purposes. AG?
Mr. Chairman, I would just add, for clarity, the original Clause 8, now shifted into this domain, had exceptions only by way of reference to Section 6, 41, 42, and 46 of the Data Protection Act. What we sought to do was to add in specifically to that number Sections 30, 31, 38, 40. Section 42 was mistakenly referred to, so we took that out, and we added in Section 69 of the Data Protection Act. That allowed specific reference to the concept of sharing, disclosing, processing, sharing across borders, and collecting of information, and the general data privacy protection principles, so that we wanted to make it tighter and clearer that this was the position specifically with respect to the Data Protection Act. Thank you.
Honourable members, as a consequence, clauses 12 to 25 are renumbered as clauses 9 to 22.
Clause 9 as renumbered.
Honourable members, the question is that clause 9 as renumbered stand part of the bill.
Mr. Deputy Speaker, we have an amendment. We have amendments to Clause 9, most of which are correcting typographical errors in the original draft. But there's a very important amendment, and that is the amendment to Clause 9, 1E, where we've taken out this form of words that cause so much grief to the opposition, the words, the authorized representative of the minister, and we're making it crystal clear now that the competent authority that will be sharing foreign account information with the U.S. Treasury will be the Board of Inland Revenue and the Board of Inland Revenue only. So instead of competent authority means the Board of Inland Revenue as the authorized representative of the minister, it is now very strict. Competent authority means the Board of Inland Revenue, full stop. And the other changes are typographical in nature. Attorney General?
Member?
Mr. Chairman, I would just add the definition of competent authority which is being proposed for amendment, as it appeared in the bill, was directly out of the intergovernmental agreement signed by the UNC as government. And therefore, notwithstanding the inconsistency of approving it in October 2013, approving it on 4 occasions, in fact, the last cabinet under the member for Siparia, notwithstanding the fact that those exact words were approved by them, we've amended it because they've said they wanted it to be amended now. And that, Mr. Chairman, inconsistency and all, inexplicable as it is, inoffensive as it is the rationale behind that. And secondly, the cross-reference changes as a result of amendments have caused us to shift from Schedule 2 to Schedule 3, etc. So apart from typographical, there's also cross-referencing amendments proposed as circulated.
Honourable members, the question is that Clause 9, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question now is that Clause 9, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 9, as renumbered and as amended, now stand part of the bill.
Clause 12 as renumbered.
The question is that clause 12 as renumbered stand part of the bill. Member?
No, did you go through 10 and 11? Okay.
I'm sorry. 10, 11, yeah, 10 and 11. Clause 10 as renumbered and clause 11 as renumbered.
The question is that clause 10 as renumbered and 11 as renumbered stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 as renumbered and clause 11 as renumbered now stands part of the bill.
Clause 12 as renumbered.
We have an amendment to clause 12.
Member?
And it's a very important form of words. In clause 12, we are adding in the following words. The disclosure of sensitive personal information under this section shall be done annually on an automatic basis. And this is exactly what is in the agreement, but this is I would say, the fundamental issue that we are facing with the United States. At this point in time, the Board of Inland Revenue responds to requests from the U.S. Treasury and has a discretion in terms of providing information. So it's not automatic. In all of these tax agreements and foreign account agreements with other countries, it is necessary to have a protocol and a machinery so that information is automatically transmitted. And that is one of our areas of most serious non-compliance, that we have no system where there's automatic disclosure of information to entities such as the U.S. Treasury. So this deals with that very, very important issue. AG?
Thank you, Mr. Chairman. I wish to point out, we have just gone through clauses 13, which became 9, 14, which became 10, 15, which became 11, and we're now dealing with 16, which becomes 12. I want to point out that the opposition has not raised any objection to these clauses. Their contribution, the sole and only contribution as to clauses in the bill, is again contained in their written publication paid for by the Parliament, labeled statement by the Leader of the Opposition, Friday 23rd September 2016. However, insofar as we had to reach in to find what on earth was meant, we took the opportunity to tighten the provisions in clause 12 as it's now numbered, and specifically I want to point out to the fact that the definition of sensitive personal information is contained in the section itself, in section 9, because that definition comes directly out of the Intergovernmental Agreement for 2016 and is the core obligation which we must obey unless we have jeopardy to our banking and financial system, and we've stayed within the four corners of the Intergovernmental Agreement. Thank you, sir.
Honourable members, the question is that clause 12, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question is that clause 12, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 12, as renumbered, as amended, now stands part of the bill.
Clauses 13 to 15 as renumbered.
The question is that clauses 13 to 15 as renumbered stand part of the bill. Those in favour, say aye. Aye. Those against, say no. I think the ayes have it.
Mr. Chairman, could I just put onto the record that all that is appearing inside of here would be the renumbering, and there was no objection raised by the opposition at all in respect of any of these clauses.
And I would also say I think we need to include 17 in that as well.
17 has a cross-reference to 12.
Instead of 13 to 15, 13 to 17.
But I see 16, 17.
Oh, sorry.
16, 17 is on the other page.
My apologies. You're right, you're right. It starts with 16. Yeah, quite true.
All in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 13 to 15, as renumbered, now stands part of the bill.
Clauses 16, 17, 18, and 19 as renumbered.
So we have some amendments. Because of the oh, I'm sorry.
The question is that clauses 13 to 19, as renumbered, stand part of the bill. Member?
Yes. Because we have made changes to the clauses and deleted the clauses that gave the minister powers, we now have to change the cross-referencing. So, for example, in clause 16, instead of 15, notwithstanding section 15, it will be notwithstanding section 12. And that occurs all the way through, down to 19, wherever 15 is mentioned, it is now 12 because 3 clauses have come out. And in clause 18, instead of a memorandum of understanding, we're changing that to an agreement. And those are the changes.
Member?
AJ, do you want to say anything?
Mr. Chairman, just to add one small comment on the new clause 18, which was old clause 22. The reason for going to an agreement as opposed to an MOU is because of the removal of the concept of a minister. The minister would have had the opportunity to deal with memoranda of understanding, but the Board of Inland Revenue itself would have to be confined to an agreement. And I wish to say just simply that.
Honorable members, the question is that clauses 13 to 19, as renumbered, stand part of the bill. Those in favor, say aye. Aye. Any against?
This is the question you have to put it for this question. This is the question.
Okay, sure. Honorable members, the question is that clauses 13 to 19, as renumbered, be amended as circulated. All in favor, say aye. Aye. Any against? The ayes have it. The question is that clauses 13 to 19, as renumbered and as amended, now stand part of the bill. All in favor, say aye. Aye. Any against? The ayes have it. Clauses 13 to 19, as renumbered and amended, now stands part of the bill.
Clause 20 as renumbered.
Honorable members, the question is that clause 20, as renumbered, stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 20 now stands part of the bill.
Clause 21 as renumbered.
Yes, a small amendment.
The question is, clause 21, as amended, as renumbered, stand part of the bill?
Again, Mr. Chairman, because we have deleted all these clauses that gave powers to the minister and replaced the minister with the Board of Inland Revenue, we have to change the numbering. So instead of section 21, it's now section 18.
Member?
Chairman, may I, for the benefit of the record, and because the opposition has refused to enter into this debate or this committee of the whole of the Parliament, put on record that in the Leader of the Opposition statement, Friday, 23rd September 2016, they had raised a position in respect of Clause 21. Clause 21 is now renumbered as Clause 17. And if you look at it, it probably was a reference, because one must try to make sense of it, to Clause 22. The opposition's, and that's the old 22, the opposition's position was that an MOU should be subject to affirmative resolution of Parliament to allow disclosure, debate, etc. For the record, this was the one clause that we had to distinguish, because of the 6 clauses raised by the opposition, we agreed to 5 of them. The one clause left was this clause 21. And I've been advised by the Chief Parliamentary Counsel and by Senior Counsel otherwise that clause 21 is attended to, not only because we've moved from the concept of a memorandum of agreement and now to an agreement itself, not only because the minister is no longer entering into memorandum of agreements or agreements at all, and it's confined to the Board of Inland Revenue, but because an agreement or an MOU, the MOU itself being the original objection, with respect to the MOU, that's not a legally binding agreement. And Section 75 of the Constitution is clear that it could not be considered a statutory instrument or any degree of subsidiary legislation. But in any event, it is a matter of policy that the government holds that the Board of Inland Revenue should not be stymied by parliamentary procedure. And in any event, we've taken care of that. I've just taken the opportunity, with your permission and leave, to raise that concern because the opposition is not here to advance its own statement. And this came in the public domain, so we wish simply to put it onto the record as having been attended to, not only by the amendments proposed today, but by virtue of the application of the law and by way of the policy and procedure which has been the position in umpteen governments since our independence. Thank you.
Honourable members, the question is that clause 21, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question is that clause 21, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 21, as renumbered and amended, now stands part of the bill.
Clause 22 as renumbered.
The question is that clause 22, as renumbered, stand part of the bill.
We have an amendment. The Income Tax Act has a reference to the 1989 Tax Information Exchange Agreement, and we felt it necessary to correct a little typo in that act and also introduce the 2016 Tax Information Exchange Agreement into the Income Tax Act. So that's the purpose of the amendment to clause 22.
22 as renumbered is simply being deleted.
Oh, I'm so sorry. I'm so sorry. I have a different thing here. We're dealing with 21 or 22? 22, the original 22.
Yeah, it's supposed to be deleted.
We're moving it to another, we're deleting it because we're moving it to another section of the bill.
Any addition, members? Right. Honourable members, the question is that clause 22, as renumbered, be deleted. All in favour, say aye. Aye. Any against? The ayes have it. Clause 22, as renumbered, is deleted. There is now a proposal for a new clause 22. This new clause will be taken at the end. However, I will allow an explanation at this time.
Yes,
Member?
Mr. Chairman, this is what I was talking about just now. We now introducing into the Income Tax Act a reference to the 2016 Foreign Account Agreement. AG?
Member?
Mr. Chairman, at this particular part of the bill, which is part 4 of the bill, we've taken the opportunity to specifically do the consequential amendments or necessary amendments to several pieces of law. 1, the Income Tax Act. 2, the Securities Act. 3, the Financial Institutions Act. 4, the Central Bank Act. These are the main pieces of law that are touching and concerning. And that's specifically because the Inland Revenue is the competent authority and therefore has to have the power under the IGA, as we see in the new clause 22, to in fact not only treat with, as it did for 27 years, the 1989 agreement, but also to treat with the 2016 agreement. This clause 22, the new clause 22, also allows for the position to be clear with respect to the domestic treatment and the extra-jurisdictional treatment of taxpayers. Further, Mr. Chairman, the position as it comes a little bit later, just to flag it now, is going to be that we ground certain powers, but I'll come to that under the second section. I want to observe the opposition has made no comment in relation to this clause, and there is no objection contained in the public utterances or publications by the opposition.
Honorable members, there is a proposal for a new clause, clause 23. This new clause will be taken at the end. However, I will now allow an explanation. Member, Minister.
Thank you, Mr. Chairman. This is a very important clause. It deals with any issues that any person may raise as to whether the central bank has the power to draft guidelines and generally get involved in the implementation of these tax information exchange agreements. To my mind, the most important thing would be the amendment to Section 36C, where we're adding a new paragraph DD after CC, where the central bank will now have the power to supervise financial institutions and insurance companies on the implementation of declared agreements. Now, somebody has to do this, Mr. Chairman, and we felt since the central bank is the entity that deals with financial institutions, that it was the most appropriate fit to give the central bank this power and also to remove any argument that the central bank does not have the power to do this. AG?
Member.
Mr. Chairman, just to add further, technically, the central bank has at law the responsibility for the stability of the financial system in Trinidad and Tobago. In those circumstances, it could very well be read into the law that the central bank has the supervisory power once it is given the inter-articulation with the banking sector. As the Honourable Minister of Finance has put onto the record, this is to make it pellucidly clear that the central bank has the authority, and it's tied in as well, Mr. Chair, to the fact that the central bank will be issuing guidelines under the respective laws that it manages, including the Financial Institutions Act. So this is to tie together the Board of Inland Revenue operating as the competent authority, dealing with the banking sector, which has the ability to be regulated by the central bank. Because the question is going to be, how does one impose a sanction, and therefore rules and regulations and guidelines have to be issued by the competent authority for banking system, which is the central bank. Thank you.
And there's something I would like to reiterate, that we're also making it clear in the Central Bank Act that the only agreements that the central bank will have to be involved with are the 1989 TI Tax Information Exchange Agreement and the 2016 Intergovernmental Agreement on Foreign Accounts.
Clauses 26 to 28 are renumbered 24 to 26. We take that at the end, member. So clauses 26 to 28 are renumbered clauses 24 to 26.
Clause 24 as renumbered.
Yeah, we have an amendment.
Right.
Again.
Member, one sec.
Sorry.
The question is that clause 24 as renumbered stand part of the bill. Proceed now, member.
Yes, again, we want to make it very clear that the only agreements that we are seeking to enshrine into domestic law, well, 1989 TIA is already there, is the tax information agreements with the United States of America, specifically the 89 agreement and the 2016 foreign account agreement. And there are some other consequential amendments, and then most importantly, we can't have the central bank just making guidelines willy-nilly. That would not be good procedure, and therefore guidelines made by the central bank shall be subject to the approval of the minister.
Member.
Mr. Chairman, it's important to observe that because of the opposition's position on this law, and again for the record, because they are not here, the government is compelled, in a special majority circumstance like this, to treat every single tax exchange on its own. I'm just flagging that every single tax exchange agreement that we enter into, we're going to have to make amendments to the same pieces of law that we're doing now on a case-by-case basis. That is for declared agreements under the Central Bank Act, Financial Institutions Act, and also the Securities Act. I think that's it.
Honourable members, the question is that Clause 24, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question is that Clause 24, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 24, as renumbered and as amended, now stands part of the bill.
Clause 25 as renumbered.
Honourable members, the question is that Clause 25 as renumbered stand part of the bill.
We have some amendments, and again, because we want to make it clear that we're dealing only with the agreements with the United States and nothing else, because of concerns expressed by persons opposite who are not opposite at this time. We are dealing with the 1989 Tax Information Agreement and the 2016 Tax Information Agreement, and we now have to do a number of amendments to the Securities Act to give effect to the two TEIAs, and again, we are putting in a section that the guidelines that are issued shall be subject to the approval of the Minister. AG?
Yeah, it's okay.
Honourable members, the question is that Clause 25, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question is that Clause 25, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 25, as renumbered and as amended, now stands part of the bill.
Clause 26 as renumbered.
The question is that Clause 26, as renumbered, stand part of the bill. Member?
Mr. Chairman, again, we are amending this Insurance Act. So we amended the Income Tax Act, the Securities Act, and this one now deals with the Insurance Act because we want to make it crystal clear we're just dealing with these particular agreements with the United States. Basically, that's the purpose of Clause 26.
Member?
Again, Mr. Chairman, just to point out, the opposition has indicated no objection to these provisions, but because we have narrowed it to only the United States 1989 agreement and the 2016 intergovernmental agreement, these are consequential amendments as a result of that.
Honourable members, the question is that Clause 26, as renumbered, be amended as circulated. All in favour, say aye. Aye. Any against? The ayes have it. The question is that Clause 26, as renumbered and as amended, now stand part of the bill. All in favour, say aye. Aye. Any against? The ayes have it. Clause 26, as renumbered and amended, now stands part of the bill.
Philosophy and deal with the procedure.
Honorable members, there is a proposal for new clause 27. This new clause will be taken at the end. However, I will allow an explanation.
Yes.
Member?
Since law is not static and agreements between sovereign nations are not static, from time to time the U.S. may wish to get our agreement to modify the agreement on foreign accounts, and this gives the minister the power to amend the agreement, not the law itself per se. AG?
Member?
Mr. Chairman, this would be exactly in keeping with how Larry Hawaii, as Minister of Finance, went to the cabinet of Mrs. Prasad Bisesa, the member for Siparia, and on 4 occasions, including the confirmation, approved the intergovernmental agreement between the United States and Trinidad and Tobago. So it is exactly the same position as how we now have the IGAs before us. Even though there's a reference to amendment, it's just want to put it clear that this is a repetition of exactly the process by which this is done right now.
Honorable members, there is a proposal for new clause 28. This new clause 28 will be taken at the end. However, I will allow an explanation at this time.
Yes, this is really a good faith clause. It doesn't say so, but this is what it means, that if the Board of Inland Revenue discloses information, and they do so in good faith, they would not be subject to any penalty or have committed any offense. So that it reads as follows: the competent authority or any person acting under its authority or direction who discloses confidential information in compliance with this act, therefore its good faith, shall not be taken as having committed an offense under the provisions of any written law related to confidentiality by reason only of disclosure. They would have to have mens rea in doing this.
Mr. Chairman, this is a very, very important clause in light of the opposition statements. Just want to put it this way. This is a standard immunity clause equivalent to Section 44D of the Central Bank Act. The opposition in the 6 years, 5.5 years while it stood as the government, specifically operated the exchange of information which occurred under the Board of Inland Revenue. They complained that there was a breach of the law and that they did not want to validate the exchange of information which they allowed the Board of Inland Revenue under the Minister of Finance, under the member for Siparia to do. It would therefore be infradig for the government to not protect people who were required to disclose information under the 1989 agreement, and the Central Bank of Trinidad and Tobago has asked for the insertion of this clause, and there's been no objection from any of the other contributors, in particular the Board of Inland Revenue, etc. Thank you.
Mr. Deputy Speaker, in accordance with Standing Order 7014, I beg to move that progress be reported to the House.
Honorable members, the question is that progress on the bill as amended be now reported to the House. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Minister of Finance.
Thank you, Mr. Deputy Speaker. I was awaiting your direction. Mr. Deputy Speaker, in accordance with Standing Order 7014, I wish to report progress that clauses 1 to 28 of a bill entitled An Act to Repeal the Tax Information Exchange Agreements Act and replace it with a new Tax Information Exchange Agreements Act, which would make provision for the implementation of agreements between Trinidad and Tobago and other states providing for the exchange of information for the purposes of taxation, to validate the sharing of personal information held by the Board of Inland Revenue or financial institutions and for related purposes were considered in the Committee of the Whole. I seek leave for the House to sit again on Friday, the 6th of January 2017, for the resumption of the proceedings. In making this report, I wish to state that amendments were made to clauses 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 5 as renumbered, 7 as renumbered, 8, in new clause 8, 12 to 25 as renumbered, 9 as renumbered, 12 as renumbered, 16, 17, 18 as renumbered, 21 as renumbered, 20, 26 to 28, including clauses 24, 25, and 26, and insertion of new clause 27 and 28, and that in these amendments we have dealt with the concerns expressed by the opposition in its advertisement dated Friday, the 23rd of September, 2016, comprehensively and in total. Mr. Deputy Speaker.
Honorable members, leave is granted for the resumption of the proceedings on Friday, 6 January 2017. Leader of Government Business.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, before requesting the adjournment of the House, I would crave your indulgence, as I had indicated to you previously, to make a very brief intervention at this point of the proceedings. Mr. Deputy Speaker, our standing orders are very clear in this Parliament. It defines the leader of the House as the person primarily responsible to the Prime Minister for the arrangement of government business in the House. Similarly, it defines the whip as a member of a party in the House who is responsible for organizing members of his party to take part in debates and votes. In debates and votes, Mr. Deputy Speaker. Mr. Deputy Speaker, for the second time in this particular debate, the opposition has, in fact, for the third time in this particular debate, Mr. Deputy Speaker, the opposition has chosen to absent itself from this very important piece of legislation, the debate on the Tax Information Exchange Agreements Act. Mr. Deputy Speaker, our Parliament is here to ensure the conduct of law and order regulations for the proper organization of our country. And Mr. Deputy Speaker, the Parliament consists of those who form the government, those of us on this side of the House, and those who are opposed to the government. Mr. Deputy Speaker, it is indeed passing strange that on 3 occasions, I repeat, those in opposition to us have determined that they should not participate in this debate. On the last occasion that they absented themselves, Mr. Deputy Speaker, they indicated that they were doing so in solidarity with their leader, the leader of the opposition, and the member for Naparima, who were ejected from the House by the Speaker for gross disorder and misconduct at the time, Mr. Deputy Speaker. And Mr. Deputy Speaker, we ask the question today, what is their reason for not being here today? And Mr. Deputy Speaker, it is very interesting that they are choosing not to participate in a debate which would authorize the Board of Inland Revenue to exchange tax information and validate the sharing of personal information and foreign account information held by the Board of Inland Revenue or other financial institutions. And we ask the question, Mr. Deputy Speaker, why are they consistently absenting themselves from such an important debate, which can, if this bill is not passed and made law, can lead to the entire collapse of the banking system in Trinidad and Tobago. And Mr. Deputy Speaker, in addition to that, even if they were absenting themselves from speaking to us in the Parliament, why are they not speaking to the Bankers Association, Mr. Deputy Speaker? They have been absenting themselves even from those requests by the Bankers Association. This is one of the ways that we can deal with white-collar crime in Trinidad and Tobago and take the profit out of crime, Mr. Deputy Speaker. And we ask the question, why are they absent? Mr. Deputy Speaker, I do not want to prolong the House on this, but I think as leader of government business, it is imperative that I speak to the people of Trinidad and Tobago and let them know that as a government, we are sitting here in their interest to ensure that this legislation is passed. And I make the point which we have made on more than one occasion, Mr. Deputy Speaker, not only in this debate but in other debates, that even when those who are opposed to us now sat on this side, once there was legislation in the interest of the people of Trinidad and Tobago, we of the People's National Movement supported that legislation, Mr. Deputy Speaker. And Mr. Deputy Speaker, as I draw to a close in my discourse, I ask the question. They have said that they will only give their vote if we agree to a joint select committee. And Mr. Deputy Speaker, a joint select committee as defined by the standing orders indicates that it is a committee of members of the House, members of the Senate. That is why it is a joint select committee. And Mr. Speaker, the maximum number is 12 members, so that if we were to set up a joint select committee of 12 members, it would be 2 members from the opposition in the House, 4 members from the government side in the House. In the Senate, it would be 3 members from the government side, 1 member from the opposition, and 1 member from the independent. At all times, Mr. Deputy Speaker, the government will continue to have the majority. What is it that they want to say behind closed doors that they cannot say to the public of Trinidad and Tobago in the committee of the whole, Mr. Deputy Speaker? This exercise allows all members, whether on the government side or on the opposition side, to say clause by clause what concerns they have for the bill. Mr. Deputy Speaker, what we did today in the Committee of the Whole was allow for any member of this chamber to say what concerns the even government members who may have concerns. All 41 members can contribute. Why would they only want 6 from this House and 6 from the Senate, Mr. Deputy Speaker, behind closed doors? And Mr. Deputy Speaker, we leave the public of Trinidad and Tobago to answer that question. And Mr. Deputy Speaker, as I end my contribution, I have to indicate that they have treated this Parliament with contempt, with scant courtesy, with gross disrespect. And let me make the point, Mr. Deputy Speaker, as the member for Digger Martin North East indicated, that they sat at level 6 of this building whilst all these proceedings were taking place, looking at it on television and inviting the media to take their photograph and publish it on social media. Mr. Deputy Speaker, contempt of the highest level for the Parliament of Trinidad and Tobago and for the people, not only the people that they represent, but all the people of Trinidad and Tobago. And Mr. Deputy Speaker, we on this side say that they have treated us in Trinidad and Tobago with total and gross disrespect. And as leader of the House and on behalf of this side of the House, we will not accept that for the people of Trinidad and Tobago. Thank you very much, Mr. Deputy Speaker.
Honourable members, before I ask for the adjournment of this House, I would like to call on, well, the opposition is not here, so I cannot call on the Chief Whip for Christmas greetings. So I'd like to call on, the member for Diego Martin Central to bring Christmas greetings on behalf of the government.
Thank you, Deputy Speaker. You know, today we heard the Chief Whip speak of the Leader of the House speak of our next day back at Parliament next year, 2017. And it's a sad way, although I'm here to bring Christmas greetings, it's a sad way to end off our calendar year in the Parliament with the opposition not being here to work with us to pass this very important bill. And the message that we've been sending to the people of Trinidad and Tobago since September 7 last year was, let's do this together. Let's work together. A simple bill like this which benefits all. They're not here to share and move together. But nevertheless, we're here to discuss and to celebrate the season that we're in. It's Christmas time. We're going into the new year, 2017. And on behalf of the government of Trinidad and Tobago, members of Parliament on this side, we want to wish the people of Trinidad and Tobago, the staff of the Parliament, all our staff who work with us every day and night at the various ministries and state agencies in our constituencies. We want to wish them all a very, very Merry Christmas and a happy 2017. And we wish to work with the people of Trinidad and Tobago, inclusive of the opposition and anybody who's willing to work with the government to make Trinidad and Tobago a better place to live in 2017. So to the media, to the Deputy Speaker and all, have a very safe Christmas and a prosperous 2017. And just remember, it's the birth of the Lord God Jesus Christ. And remember that in your giving, to give some quiet time to reflect on that. As Christians, as you know, it's one of the more popular holidays that is ventilated through many different religions across the world, to ensure that we celebrate the birth of Christ, which is the most important part of this. So Merry Christmas to all of Trinidad and Tobago. God bless.
Honourable members, I join this House in conveying greetings to the national community of Trinidad and Tobago and to all the honourable members on this occasion of this holy season of Christmas. I do this on behalf of the Speaker, who is abroad on government business at this time, and also on behalf of myself as the Deputy Speaker of this House. So I wish to extend at this time a Merry Christmas to all the citizens of Trinidad and Tobago and a bright and prosperous 2017, and to remind our national public that to continue to be safe on the road and do have a holy season. I thank you. Honourable members, the question is that this House do now adjourn to Friday, 6 January 2017. All in favour, say aye. Aye. Any against? The Leader of Government Business did not give a time. But standard time, members? Standard time. 1:30. Right. Honourable members, the question is that this House do now adjourn to Friday, 6 January 2017 at 1:30 p.m. All in favour, say aye. Aye. Any against? The ayes have it. This House now stands adjourned to Friday, 6 January 2017 at 1:30 p.m.